Well, thank you, Rick and the panel. I think we'll run through here and see if we have any other comments from folks on the panel. Marty?
Well, I should emphasize that substantively this isn't my area. The closest I've come to dealing with a public nuisance is trying to get a student to shut up in class, unsuccessfully usually. But I do focus in the areas of the Constitution and procedure, and I think the problem I raised about contingent fee lawyers is a serious one that I'm not sure Joshua really responded. As I heard Joshua's arguments, there were two key points. One, there really is a check on these contingent fee lawyers because they're not making the decisions, but the client really is, at least the important decisions. And secondly, there's a pragmatic justification because absent the use of these contingent fee attorneys, the states and the municipalities simply don't have the resources. As to the first point, I don't think it would be sufficient if you had a U.S. attorney in charge of a criminal prosecution being paid on a contingent basis if he or she had a supervisor who was not being paid that way. I've never seen any of the ethical discussions of this issue turn in any way on how much supervision the person in the trenches had. How much supervision actually is going on would be difficult to determine in the individual case. The contingent fee attorneys are the ones who were in the trenches on top of everything, who were brought in for their expertise. It's by no means clear that their advice is going to be ignored, at least ex ante. I don't think we can count on that as a means of neutralizing or even diluting the constitutional pathology that I raised. As to the pragmatic justification, I have told my children, you can't buy a Lexus when all you want to pay for is a Yugo. You might want it. I mean, sure, what the heck? But you usually get what you're willing to pay for. And if cities and states don't want to raise the revenue by raising taxes, then their citizens will get what they pay for. We seem to have gotten in a mindset now that raising taxes is off the table. You simply can't do it. And maybe politically that's true. As a physical or legal matter, however, that's an option. If the states don't have the resources to bring the suits now, they've got two options. One, don't bring the suit, or raise taxes so you can bring the suits. And that's up to those who are elected by the people and by the people themselves in voting on increases in taxes. I get very nervous when I hear pragmatic justifications being used as a means of authorizing encroachments on the Constitution. I'm not an absolutist, I'm not a formalist, but there has to be some kind of due process floor, or else you could just eat it up by the inconvenience that it's going to cause.
I just want to comment on the notion that this is committed to another branch of government. That was the exact argument made to the U.S. Supreme Court. The reason we're in the court pushing these issues is because it's not. The fact that Congress has not enacted legislation that governs global warming or greenhouse gases is precisely the vacuum that's left, which allows, under the law, the Supreme Court precedent, allows you to pursue, if you have interstate pollution of an unregulated pollutant, okay? Interstate pollution, unregulated pollutant, federal common law steps in. And there is no regulation currently on greenhouse gases, but there is a wealth of science that has been published over the last 3 years, including and Justice Stevens quotes it in the opening paragraph of the decision where he castigates the EPA. And he says, for the Supreme Court, that there's no question that massive amounts of carbon dioxide and other global warming gases that have been released by a process that is not natural, in essence, heavy combustion and refining, is contributing to global warming. The next issue on this political question, and it is correct, the decisions that have been California filed and the up east AEP versus the EPA, there are other decisions, they have been dismissed on political grounds. But if you look carefully at those decisions, they turned on a significant fact. That was the EPA had taken a position that global warming gases, in particular carbon dioxide, were not a pollutant and were not subject to regulation. That underpinning was reversed in 2007 by the Supreme Court. So our position is those cases need to be read skeptically. They were based on the assumption that this was a regulated pollutant, hence committed to another branch of the government. It's not. And so I think what will happen, I mean, my own personal view is that with the new administration, we're going to have regulation. And once the regulation gets put into place, then public federal common law under the Supreme Court won't exist anymore because it'll be preempted.
Well, I guess I find myself in between Eric, literally in between Eric and Richard, and also figuratively. On the one hand, as a law professor, I think it is hard to know the difference between public and private and where to draw those lines. I mean, it is a public nuisance in the case law if you have a factory that spews pollution over a big area. But that's all a matter of degree between, you having a charcoal fire in your backyard or barbecue and affecting your neighbors. So the size of the phenomenon does matter. On the other hand, I don't think you can quite elide all these difficult questions by saying it'll go to a jury and the jury will be sensible. Maybe jurors are sensible, but still some things probably aren't properly brought before them. I do tend to agree that Mass versus EPA and more generally the change in administration is going to mean that there is going to be significant substantive regulation over greenhouse gases under federal law, which will more clearly preempt a lot of this litigation. And I guess it'll be an historical question whether the litigation was just help the thing go along or whether it was an interference or how you view it. But I think that is the likely outcome. The only other thing I'd say as kind of a property professor is it's interesting to me to hear about the subprime litigation because all of English law about mortgages and how we got the right of foreclosure in the first place were courts kind of making things up after you have a housing crisis, basically. After all these, tenants and farmers were being thrown off their land, they kind of made things up, the courts, because they had to try to help people out. And they sort of invented new rights. And there is this historical tradition of the courts and the role of equity coming in. And then the legislatures have to clean it up after. And I don't know you're going to get that lucky, but there is a kind of a nice historical story you might tell. Joshua.
I just want to address, Richard raised the point of loss causation and suggesting that we didn't have to, I think, attribute individual foreclosures to defendants, individual defendants. That's not the case that we're bringing. We intend to do that. And we are going to have to prove proximate causation and show that there was a direct link between the defendant's conduct and individual foreclosures. But we think we can do that. Proximate causation in Ohio law says that if you put in, trigger a chain of events that leads directly to the outcome in question, that's sufficient to establish proximate cause. And we believe if we show that these financiers were injecting subprime money into Cleveland knowing that the foreclosure rates on the default rates on these are going to be exceedingly high because the populace just can't absorb this kind of money given the economic conditions that prevail there, given the housing conditions that prevail there, that will be sufficient to establish proximate causation. Second thing, just on one last word from me on the issue of contingency lawyers, I just want to point out, and I haven't read these in a while, so I don't want to say too much about them, but there have been a few decisions that have said that cities can engage contingency lawyers to represent them so long as the state's attorney or the city's attorneys maintain sufficient control over the case. I believe the Rhode Island Supreme Court decision in lead paint was one of them. So that's what I have.
Yeah, we should note that this contingent fee argument is a really vibrant argument right now, and it's not only vibrant in public nuisance, it's vibrant in all kinds of cases where a city or a state would delegate that kind of responsibility to a contingent fee lawyer. This whole matter is going up and is before the California Supreme Court right now on the issue of whether or not the lower court's acceptance of a control feature by the county of Santa Clara is enough to avoid the ethical issues. It's also was essentially decided to some degree by the Rhode Island Supreme Court that was in fact sufficient basis for permitting such matters to go forward. There's a tremendous amount of arguments, all of which Professor Reddish has done, that suggests that they're probably wrong on those issues. We'll just have to see where that comes from. I get more and more susceptible to Josh's arguments every time I tune in and see where my 401k is at the moment. I first debated Josh over this at the ABA annual convention in New York this summer, and I was strident, completely strident, that under no circumstances should the financial institutions be responsible for the subprime mortgage crisis. However, when you get into situations where they might be responsible for every retirement account in the country, including your own, you tend to be a little bit more open to the argument. And it's not only scale that makes a difference in these situations. I think that what we see, especially in the financial crisis litigation these days, including that which Josh is bringing and issues in other cases, is that rage tends to make common law uncommon. It tends to change the way that judges and juries feel about the common law and how the common law should be used and how it should be transformed to deal with severe societal problems. And I can't tell you prudentially or jurisprudentially, because I'm not a judge, how it feels to deal with that. But I do think that there's a tremendous amount of rage over the financial issues going on in this country. And I suspect that it's more likely that you're going to see the financial public nuisance cases come before you, like Josh's, than you are to see the climate change cases come before you, or the lead paint cases, which deal with products liability, which has now been fairly uniformly discredited, subject to the Supreme Court of California's review.
Great. Well, let's open it up for questions now. Starting here on the front row. Hold on for the mic. Right here on the front row. The reason for the miking is that we're recording this. It's not just so the speakers and everyone else can hear it. So I appreciate
2 points and then a question. First, Dr. Butler, this is a great program. You could go 2 days just on this. These are wonderful speakers. Secondly, being a judge, we get all kinds of things in the mail, and one of them is a summary of an English case that says that global warming is a political issue, not a scientific one. There was a lawsuit brought by a parent of a kid who was taught about global warming in school, and the father objected, saying it wasn't fair, and he brought suit under some English law, and there's a English judgment that says it's a political problem, not a scientific one. Thirdly, my question is, in San Jose, where I am in Santa Clara County, the building department used to have one inspector for abandoned homes. Now they have 20. And the median prices of homes in that county is about $800,000. And I saw this when I was handling law and motion discovery department 2-3 years ago, that there were foreclosure problems, loan problems with unscrupulous brokers, owners that overstated their income, their assets, or where property fell apart just because of problems completely unrelated to the mortgage for whatever reason. How do you parcel out the issues on causation between the banking industry, between the brokers, between real estate crooks, between unscrupulous loan applicants, and how do you come to a determination that on issues of causation? On California, we have a substantial factor test for causation, not proximate cause. But you know, when it's so widespread, and I'd like to direct this to Mr. Cohen and Mr. Mayor. How do you plan on portioning out causation on these problems? And then I guess Professor Dana can help with the William Douglas real estate zoning case in 1948 that said zoning issues are political problems, not judicial ones, and so on. In a case where a man whose property was not deteriorated was objecting to an urban renewal plan involving his property. So those are the things I'm interested in hearing.
What I would say is that from a legalistic perspective, the initial answer would be that an injury can have more than one proximate cause. And one of the things that there's a finding as part of the Cleveland building ordinance is that just an abandoned house purely on the basis of abandonment creates a public nuisance, because I think that the thinking is that the abandonment enhances the possibility of the sort of things that you're talking about. So our argument, I guess, would be that if I can show the causal link between that circumstance and what the defendants did, that would keep them in the running as at least one of the proximate causes of what took place here. And I wouldn't have to necessarily factor out all of the other circumstances that contribute to that.
I'll respond to, you had 2 points, I think, that I heard. One was this question about whether global warming is political or is it scientific. And I think, you know, a lot of issues are political, or people believe they're political, but under our system, if someone's been damaged and they have real injury and they can seek redress, the courts have, I think it's an unflagging obligation to resolve them, and they should not step out of the mix on a political basis unless truly that issue is committed to another branch of the government under the U.S. Constitution. And, you know, that's the test. And the preemption cases over time have made clear that you've got to look and see whether the issue is really preempted or not. And on a political question, you know, the point I would make is that the courts should not step out of the mix on the political question, because this is the case, the one that we're involved in. This is a village, which is a municipality in Alaska, and it's also an independent Indian nation under a treaty with the United States in 1934. Those people have fiduciary responsibilities to their citizens. Now, let's not forget that. If they see that their homeland is being washed away through erosion, don't they have an obligation to take some action to protect the people for whom they're responsible? And there are tools in the legal system for those individuals to seek redress. And that's what they have done. On the causation, you asked me the other good question, which is, hey, you know, there's so many people, how are you possibly going to do that? I mean, we do have a conspiracy claim it's not all of the companies, but we identify a set number of companies that we believe, we have alleged, have engaged in a conspiracy to generate doubt about global warming and to create a doubt in the science. And so if we're correct on that, then if you're part of the conspiracy, then you're going to be responsible and there's no apportionment. But there's also a developed body of law in pollution cases that say that if you contribute to the pollution, you are jointly and severably liable for it under nuisance, public nuisance, federal common law. And that's another way that we hope to get there. I mean, the case that we talked about the typhoid, you know, dumping the sewage in the river, it goes down to Missouri. The question is, did it cause people to have an increase in typhoid fever? I mean, at one level, that was a political dispute, right? It's a dispute between states. And it was clearly resolved by the Supreme Court, and I might add, after a full evidentiary hearing. Okay, they didn't dodge it on political grounds. They didn't say we can't figure out who's responsible. They didn't say this is, you know, science that we don't understand. They had a full evidentiary hearing and found the other way.
I just say is about the old urban renewal cases. You know, it's clear from those cases that the locality has broad political authority to declare dilapidated buildings public nuisances, or even an area where there's buildings that aren't dilapidated, if it's affecting it, and they can condemn them, they can do lots of things. I don't know if you can step from that to say they can then sue for damages to the lenders, you know, because public nuisance traditionally, first of all, isn't really a damages action usually in that way, and that's really the stretch that they're trying to make. And so saying it's a public nuisance is clear. The buildings are public nuisances, but that doesn't necessarily mean you have a public nuisance damages action.
Mr. Cohen, I would like to ask you, will you have to prove liability 30,000 times?
Pardon?
Won't you have to prove on each count of on each foreclosure that these financial institutions were primarily responsible for the result, for the cause? Don't you have to prove that every time? And then what about apportionment of damages after you've proven liability?
I don't think that we have to prove it with respect to each individual mortgage. I think that what we can show is that they knew in pervasively financing, pervasively supporting subprime financing in this locale, that they were increasing the likelihood of these foreclosures. That's what our theory is. I don't think that, practically speaking, we can't do that.
Well, that was my point. And then, so you're assuming liability on the part of the lender each time? You just assume liability and seek damages? Is that, and then how are you going to apportion the damage?
We're going to apportion the damages. What we're going to do is we're going to match up foreclosures according to who securitized the mortgage, who financed the mortgage.
What if they didn't wrongfully finance it? What if it was a good, I mean, you can't just assume because you have a handful or 100 or 1,000 or 3,000 that you've got 17,000, can you? We believe that when the securitizers financed this, that there was evidence that they had that said that going into the Cleveland market is going to result in high rates of foreclosure and in high rates of default. So it may be that what happens is the damages that are apportioned are saying, okay, if there were 100 defaults that are attributable to one securitizer, maybe the damages won't be assessed with respect to all 100. It may be apportioned according to what their projections were. But it's not, the fact is that they foresaw, according to our allegations, that what they were doing was inflicting upon the city a elevated, extreme foreclosure rate based on their financing activities.
Next question is up here in the back, in the middle, and then we've got one over here and down here.
This is really, first of all, let me preface this with Mr. Falk. I like your statement. I tend to be on your side on this issue, but I have a problem with Professor Reddish's raising the skeleton of ethical impropriety on Mr. Cohen for seeking a fee under the contingency program. And the United States has created a host of public deputy attorney generals to prosecute U.S. Code 42, the Section 1983 civil rights actions, and that's all perfectly ethical, and they're getting the same sordid money. I think that there is some, although it's not on all fours, I think there's some valid analogous concept here that the public domain or the public nuisance lawyers could get a contingency fee. And if you do perceive that this is an unethical behavior on the part of the plaintiff's bar, what specific unethicality do you perceive?
I assume that's directed at me.
Professor Reddish.
Yeah.
Please.
He agreed with me.
Well, I was going to say,
I'm trying to speak. I'm
you were
really
saying
trying
bad
to.
things about me to you. I think.
Really trying to split you two real.
Well, if I could enter in. I don't think the 1983 analogy is appropriate. I think you have a better analogy with qui tam actions, but I think those are distinguishable too. The reason 1983 actions aren't analogous is those are situations where those attorneys are representing somebody who was injured in fact. They may be simultaneously or incidentally serving a private attorney general function as you've described it, because the substantive law, by creating a private compensatory damage remedy, incentivizes private individuals in pursuing their own rights to simultaneously and incidentally further the public interest. But that is by no means the same thing as situations where the state itself is the active plaintiff in the situation. Michael Dorff of, I guess he's at Cornell now, has argued an analogy to qui tam actions, or the False Claims Act, where private individuals who are not in fact injured can bring an action on behalf of the government and be compensated for it. But that really, and that's closer than a 1983 action, which is simply a private damage remedy that may have the effect of furthering state interests. But the reason qui tam doesn't work is that the Supreme Court has conceptualized qui tam, and this is the only reason these suits are constitutional, as assignments by the government of part of their claim to these private individuals. It would just be a complete sham to argue that's what's going on with private contingent fee lawyers. And the ethical problem is that the public interest will not be furthered by making their decisions, but that the decisions will be made on the basis of narrow private financial interests. And I think the ethical problems are pretty well established. If you look at the restatement of ethics, you look at the Berger line of cases going through DC Circuit cases written by Judge Mikva in the civil area, the ethical problems for government attorneys having these kinds of pathological incentives, I think, is quite clear. I'm just simply saying that they can't circumvent those ethical problems when they delegate it to a private individual any more than they could avoid 14th Amendment equal protection problems when they delegate the power to have schools to so-called private individuals.
Yes, in my 501 or 401k, there's a whole bundle of mortgage indebtedness. What's happened is that much of what used to be individualized debt securities has now become bundled. And the question I had for the panel is, how do you see this spilling out? Because as far as I am concerned, there's a point at which there's a contamination within neighborhoods, and can people who are simply holding a little piece of equity in a portfolio, can they hide behind that when the neighborhood is, shall we say, going to hell in a handbasket?
Well, I think that the liability that we're trying to establish is not, doesn't extend to the investor, and it extends to the securitizer, to the investment bank that put together that bundle. And the reason that we're looking at that is that because in 2002, 2003, they became very active in composing that bundle. They became, I mean, we know that there were offerings that were done to investors before they even had bought any mortgages. And we also know that there were instances where they said to lenders, go out and get me this, 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 and this. So that's why we feel comfortable in saying that we can hold the securitizers, the investment banks, responsible for that. I don't think it would be a viable case to suggest that investors, the ones who bought the mortgage-backed securities, would in some way be responsible for that, because they wouldn't have been privy to the macro analysis and the risk evaluations that presumably were done in-house at these investment banks.
One thing, though, that I think that he makes an interesting point. Those of us that began with the asbestos crisis in the late 60s and 70s had no possible way to think that some of the people who are getting sued for asbestos-related injuries these days could remotely be reached by liability. And I think there's a truism here, and you guys, I'm sure, have seen it, that, you know, liability inexorably follows those who have the money to pay for the liability. And sometimes that inclination leads the creation of new causes of action and liabilities. That happens. So we may see in the future that those circumstances put people at risk. I don't know.
Yeah, when I was talking to the city about before we brought the suit, and they were saying, you know, who should we sue? I said, well, listen, you can be, one thing's for sure, you sue Bear Stearns and Lehman Brothers, they'll be here at the end, no question.
One thing is, one proposal at the federal level is to try to get more mortgages reworked, because one concern is that when you divvy up all these mortgages into pools, it's harder to get everyone's consent to reworking them. So is that something that the city considered seeking, some kind of injunctive relief to try, going forward to try to get?
It's something that we studiously avoided because
there were no damages in it? Or?
No, it's because well, no, because yeah, what's in it for me? Right. No, because one of the things that we have to deal with is a suggestion that what the city is trying to do is to regulate, and that to the extent that we're asking for any sort of abatement sorts of things or to alter conduct, we believe that that would play into that sort of defense, which is a key defense that they're raising.
Based on preemption?
Right, yeah, and actually, yeah, state preemption. And so we decided that the safest course would be to go to pure damages, and also because there are other governmental agencies that are working toward that sort of thing.
Mr. Cohen, if you are postulating that the securitization industry knew or should have known that they were lending too much money to Cleveland, that the market couldn't bear these mortgages, and therefore that there was going to be an inordinate rate of foreclosure, how do you deal with the next logical response? Then if that's the case, clearly the mortgages were going to be worthless, and that the securities they were selling themselves were worthless. And in other words, that you're basically saying that these people were
acting against their financial self-interest.
Acting against their financial self-interest, and now we're getting the snake oil salesman.
Well, what we think that we can show is that it was not worth their financial. It wasn't worthwhile for them financially to put in the filters that they would have had to put in to make these corrections. That, look, I mean, you see now, I mean, what's happened in the last few months, that there was a lot of irrational activity going on that, for things based on perverse incentives. There were people that were making a lot of money for getting these deals done and whatever. And our understanding is that to put in the sort of screens that it would have taken to weed out geographical areas and were so complicated and so costly that they didn't want to bother to do it. And that's why it didn't happen. And the reason that's also particularly true is because weeding out Cleveland would have entailed going contrary to one of their primary marketing focuses, which is marketing heavily in African American neighborhoods. We do not have a fair housing element to our case. Baltimore has brought a case like that, but we do know that the statistics showed, and that one graph that I had that showed the heavy predominance of foreclosures on the east side of the city, though that's an African American side of the city, minority area. They marketed very heavily there, and the HUD had been looking at that, since 1999. So it would have required them to do some very significant alterations to their overall marketing plan, and that's why we don't think that they put in those filters in connection with Cleveland.
Interesting. Do we have one more question?
Just two things. First, the problems that I'm experiencing in my part with respect to finding who has the ability to make a decision is that there's the servicer and there's the lender, and right now there's not a lot of communication between them. But Mr. Cohen, I'm just wondering if they refuse to give loans in Cleveland that they gave everywhere else, wouldn't somebody be suing them for redlining?
The way, I mean, it's kind of pat, but the way we have formulated that is that redlining was discriminatory lending. What we're alleging is indiscriminate lending. And that both of them were exploitative. And so, I mean, it's clearly something that we've anticipated. It was in the blogosphere the day after we filed the suit. And, you know, we don't think that the two things are analogous. You know, we also get the thing is, why are you doing this? No bank will ever want to do business in Cleveland again. So,
how do you answer that? Okay. Wait, one final question I believe we have back here. Is that right? Or we know?
This whole discussion is very, reminds me of the tobacco case in Florida when Governor Childs felt that he didn't have the resources, the manpower, or the technical ability to take on tobacco. So he hired the best contingent fee personal injury lawyers in the state of Florida, and the state of Florida recouped billions of dollars. And it was that kind of ingenuity and that kind of talent that was able to develop tort law, and I think you gentlemen are in the process of doing that.
Thank you.
yeah.
Hey, I need a job, you know? We need work up here.
Okay. This is the final question.
This is to Mr. Cohen. In your liability paradigm, how do we deal with federal agencies requiring banks to issue non-standard loans?
I didn't hear you.
How do we deal in your liability paradigm with federal agencies requiring banks to issue non-standard loans in order to deal with the redlining earlier mentioned?
To be honest with you, it's not an issue that we have spent a lot of time thinking about. But we don't think that, first of all, the majority of the entities we sued wouldn't be subject to the federal requirements that you're talking about. The investment banks wouldn't be. The federal banks would be subject to the regulations that you're requiring. And I'm not conversant enough with the statute to give you an intelligent answer to that. Obviously, it's something that we'll have to deal with.
Well, please join me in thanking the panel for a very enlightening discussion.